behalf of Harvard Bookstore, I'm pleased to introduce tonight's program with Michael Waldman, discussing his book, The Second Amendment, a Biography. Michael Waldman is an author and commentator on law and policy. He is president of the Brennan Center for Justice at NYU School of Law, which is a nonpartisan law and policy institute that focuses on improving the systems of democracy and the Constitution. He was Director of Speechwriting for President Clinton from 1995 to 1999, and his previous publications include My Fellow Americans and POTUS Speaks. Tonight he'll be discussing his latest book, The Second Amendment, a Biography, which traces the origins and trajectory of the Second Amendment across the centuries. The LA Times writes that Waldman's calm tone and habit of taking the long view offers a refreshing tonic in this most loaded of debates. And the Chicago Tribune calls it an insightful look at both the historical foundation of the Second Amendment and the successful campaign by the National Rifle Association and constitutional originalists to restore it. We're very pleased to bring the conversation to Harvard Bookstore tonight. Please join me in welcoming Michael Waldman.
Thank you all so much for being here. It is wonderful to be with old friends and with family. My family lived a few blocks away down at Quincy House about 14 or 15 years ago during a brief sojourn here, and this was our neighborhood bookstore, and it's wonderful to see it thriving and full, and I'm really delighted to be a part of it. This is, of course, a topic that provokes intense interest and debate. How did we get to this point? Just a few weeks ago, we saw the way in which this constitutional provision, the Second Amendment, couches and conditions and intrudes on even the most harsh acts of violence. Just a few hours after the horrific school shooting out in Santa Barbara, the father of one of the victims, Richard Martinez, had the presence of mind to hold a press conference and say, they talk about gun rights, well, what about my son Christopher's right to live? And then just a few days later came a rebuttal from, in a rather vulgar way, from Joseph Wurzelbacher, Joe the plumber from the 2008 election, who said, he actually said, quote, "I'm sorry for your dead kids, but they don't trump my constitutional rights." How has it gotten to the point where the question of guns and gun violence and the role of guns in America has become such a matter of constitutional debate? It wasn't always that way. And that story of how the Second Amendment has been understood, how it has been seen by different generations, how the way we've seen it has changed, it's part of the American story, and it's what I wanted to understand in researching and writing this book. The Second Amendment, as I'm sure you all know, is part of the Bill of Rights. It's only 27 words long. It's, in fact, I believe, the shortest sentence in the Constitution. It reads in its entirety, "A well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms, comma, shall not be infringed." And what people don't recognize, what people are often surprised to learn, even aficionados are often quite surprised to learn, that the Supreme Court of the United States never ruled that that Second Amendment recognizes an individual right to gun ownership until 2008. It was really recent. And that was in the case D.C., District of Columbia versus Heller. That was the first time. In fact, it had ruled otherwise repeatedly before that. That case was authored by Justice Antonin Scalia. And he was very proud of it, and he said that this was, in his words, the vindication of his philosophy of originalism. The idea that the only legitimate way to understand a constitutional provision and its meaning was to ask what it meant at the time to the people of the founding generation when they ratified it. So I wanted, in understanding the Second Amendment and telling the story of it, to start by asking what it meant back then and what the history of it was. And through the course of all of this, I found, at least for me, a number of surprises. I started working on this book after Newtown, when it was just intensely being debated again, when the Second Amendment was once again, for the first time, front and center in the debate. And I found a number of surprises. I think things that will surprise liberals and conservatives and whatever point of view you might have on the gun debate. It turns out that the way we see the Second Amendment is not due to some pristine text, but due always to the push and pull, the rough and tumble of political debate, political agitation, and public engagement. That's the way it was from the very beginning. That's the way it has been, and certainly that's the way it is now. So what was that beginning? A lot of the story, turns out, actually takes place not very far from here, within a few miles of here, because Boston, of course, was the epicenter of the American Revolution. The book actually starts 16 miles away in Lexington and Concord, where the Minutemen waged battle that launched the American Revolution. That was the well-regulated militia, and it turns out that those militias were deeply, deeply, deeply important to the founding generation. It was not throat-clearing, the way we sometimes think it might have been the case as we try to parse that confusing amendment. The militias were very important and, in fact, at the center of their political philosophy in many ways. But those militias were not like anything we have or know today in the United States. Every adult man, eventually every adult white man, was in the militia for their entire adult life. And they were required by law to own a gun and keep it at home and bring it in for the militia service. And they saw this not only as a way to keep the peace. There were no police in those days. There were no other sort of public safety forces. But even more than that, they saw the militias as a way to ward off tyranny, to ward off what they were terrified of, which was the specter of a standing army, as they called it, which was like what King George had with the British regulars. It was a professional army with paid soldiers who could be a source of oppression and of dictatorship. And they were very worried about that. And they saw the militias with their citizen soldiers and their guns stashed at home as the way to fight it off against those standing armies. That was the beginning of the revolution. As it turned out, the militias just didn't fight all that well. And they eventually pretty quickly concluded they needed an actual army. And of course, we know that George Washington took command. But they still glorified those militias in their thinking, in their public statements and in their thinking. And you, of course, know the story. The revolution occurred, the war ended, the British army sailed away, and pretty fast the United States started veering toward what we would consider to be a failed state, with a broken government and mob violence. Again, some of that happening here in Massachusetts with Shays' Rebellion in the western part of the state. And many of the leading figures of the new country went into secret to write what eventually was the Constitution. And they were young men mostly, and mostly many of them had served in the Army, in the Continental Army, not in the militias. And the Constitution they drafted and crafted emphatically thrust toward a much stronger central government. And you know the story that when it was released, there was a roaring debate over this new Constitution, a huge controversy over whether to ratify it, and whether, in fact, it was creating too strong a central government. One of the things people were worried about, not the main thing, but one of the things was the fact that it could have an army. The new government could have an army, that it wasn't prohibited in the Constitution, and they were terrified that it could crush the 13 state militias that were the principal military force of the government at the time. That fear led directly to the Second Amendment. And you also know the story that the Constitution went from state to state. It got ratified, but it was very controversial. And finally, here in Massachusetts, John Hancock and John Adams, the old patriots, came in and turned the tide for ratification. They did what we in the Clinton White House would call triangulation. They said, well, we're going to be for the Constitution, which sort of shocked everybody, but we think there ought to be amendments. And so that began to be how the states ratified the Constitution. They would ratify it, but they would say we should amend it later. And the states wound up sending in dozens and dozens and dozens of amendments on all different kinds of things, saying this ought to be part of the Constitution after it's ratified. The new Congress meets. James Madison, of course, plays in all of this a very central role. Madison helped craft the Constitution. He helped write, of course, the Federalist Papers arguing that it shouldn't be amended and that it was fine as is. And then he ran for Congress for the first time in the first congressional election. He had a very tough race. They gerrymandered his district well before Elbridge Gerry here in Massachusetts gave his name to gerrymandering. Madison was the first one to be gerrymandered. The only part of his district that was pro-Constitution basically was his house. And it turned out that the swing vote was the Baptists. The Southern Baptists now are a very conservative political force. Then they were the religious freethinkers, and they had been oppressed by the Episcopalians in the district. And they said, we'll support you, Madison, if you come out, if you change your position and come out for a religious freedom amendment, which of course is the First Amendment. And so Madison executed the very first great flip-flop in American political history and switched his position, issued a statement that reads like it was written today, saying circumstances have, yes, it's true, I'm against amendments, but circumstances have changed. Tens of thousands of politicians ever since then have said it less eloquently. He won by 339 votes, and he was elected to Congress. And when he got there, he realized all the other people had not supported amendments, and he had a very hard time getting them to listen, to pay attention. He had to fight and fight and fight. It was a wonderful thing to learn this history and to recount it. He got up, he eventually proposed 20 amendments on topics ranging from the size of congressional districts to congressional pay to the things we now know as the Bill of Rights. And it was rewritten and rewritten. And part of one of the Bill of Rights, the Second Amendment was originally the Fifth Amendment. That was part of it. Well, what did they mean? What do those convoluted phrases mean? Part of the answer is we can't entirely know. We know that their thinking was very different, that they were very focused on the militias. We know that it's hard to pierce through the fog of history to fully know what they mean. But the fact of the matter is this, and this is a surprise when you think of how intense the debates today are about gun rights and the individual right of gun ownership for things like self-protection or hunting or anything like that, all the things we think about and talk about now. There is not a single word in the notes Madison took of the Constitutional Convention, in the records, with a few scattered exceptions, of the ratification conventions, or on the debate on the floor of the House of Representatives about the Second Amendment. There's not a single word about gun ownership, protecting the right of gun ownership for personal protection or hunting or anything other than malicious service. Not a word. In fact, Madison's original proposal for the Second Amendment had a conscientious objector clause. It said if you have religious scruples about bearing arms, you don't have to do your military service in person. That's actually the wording. And that's what they debated. It was all about the militias. That's a surprise to people. People ask me, as you can imagine, so what was it? An individual right or the militias? And the answer is it was both, and it was neither. It was an individual right to fulfill the civic duty to serve in the militia. Our question would make no sense at all to the framers, just like in some ways their answer makes no sense to us. Now I want to be very clear. There were plenty of guns. And the colonists and then the Americans believed they had the right to protect themselves. There was a right under British common law. Blackstone, the great jurist, wrote about it. They had a right to protect themselves, especially in their homes. But it was governed, as I say, by common law. And they didn't think they were necessarily putting that into the Constitution. And at the same time that they had guns and the expectation of being able to own guns, they also had ubiquitous gun laws and gun safety laws and gun control laws. Here in the city of Boston, it was illegal to keep a loaded gun in your home for safety reasons. They blew up, In other cities, including Boston, Philadelphia, you couldn't fire a gun inside city limits. There were all kinds of limits on who could own guns. You had to have a loyalty oath. The wrong kind of people weren't allowed to have them. There were plenty of gun laws along with guns. But as I say, those were considered to be state law and governed by criminal law and common law, and not something they thought they were putting in the Constitution. That was all somewhat surprising, and I think raises the question in some ways of what we can really learn from, can we get the answer to what to do about the Second Amendment just by going back in a time machine and tapping James Madison on the shoulder and asking him what to do? Another thing that makes that really hard is that as soon as they ratified the Second Amendment, the militia system that they cherished so much, that they talked about so much, began to fall apart. People stopped showing up for militia duty. They just stopped showing up. Congress passed a law 2 months in requiring everybody to buy a gun, and people wouldn't do it. Thomas Jefferson, there actually were gun registries. Jefferson said, we need that registry of all the guns, and he couldn't get the bureaucrats of the federal government to do it. And the militias turned out not to be a very good way to protect the country. Madison and the Federalists had said that these citizen soldiers, 500,000 strong, would keep the country safe. In the War of 1812, as you know, first of all, the militias up here in New England refused to participate. The Maryland militia of 7,000 people was supposed to block the British. The British brushed right past them and burned down James Madison's house, the White House. And after that, they stopped thinking the militias were going to be enough to protect the country. So the country changed. It grew more individualist, moved out west, grew more commercial in its orientation. People's understanding of their gun rights began to be more personal. And all along, you had guns. I always say, you know, there were plenty of guns. Ask Alexander Hamilton. They had guns in those days. But there were gun rights and there were gun regulations that grew up side by side. In the Wild West, that was even true. There's a wonderful photograph from Dodge City, the archetypal frontier town, you know, from the 1880s, and it looks like a movie set. It's a dusty main street. Looks like it would be at the Universal Studios tour of movie sets of a Western. Dusty main street and the saloon doors and the hitching posts and so forth. And in the middle it says, "Welcome to Dodge City, firearms prohibited." So all throughout American history, you had guns and you had gun laws. The Supreme Court repeatedly stayed out of it, ruling most recently in 1939 that the purpose of the Second Amendment was the militias and didn't protect individual gun rights. And these decisions, the debates about what to do about these laws were made at the ballot box in legislatures and not through constitutional doctrine. In 1991, reflecting what was then the strong conventional wisdom, Warren Burger, the retired Chief Justice of the United States, who, as you know, was a rock-ribbed conservative appointed by Richard Nixon, said that the idea that the Second Amendment reflects and recognizes an unlimited individual right to gun ownership was, Warren Burger said, quote, "a fraud on the public." That was what people thought then. What changed? What changed? Well, that's another surprise. What changed was the role of the National Rifle Association. We all know the NRA as a powerful force in politics. It turns out to have waged a very powerful and very effective campaign for constitutional change, the way you have happening all throughout American history. So the NRA on its website says it's the country's longest standing civil rights organization. It didn't really start that way. It actually was started by Union officers after the Civil War who were very concerned about poor marksmanship by the troops. And so they created the NRA. They focused, on training, on safety, on teaching marksmanship, on military preparedness. Eventually the NRA, as we know, became known as a hunters organization for sportsmen. It was never wild about gun control laws, but it didn't really oppose them very strongly either. In 1939, in the 1930s, when the first federal gun law was passed, it testified in support of the law. A member of Congress asked the NRA official, is there any constitutional provision you can think of that might, that this might run afoul of? And the NRA representative said, none that we can think of. Things changed in the 1970s. You know, we all think about the 1960s, we know about the massive social changes and disruptions that occurred then. But the reaction to the 1960s in the 1970s turned out to have a longer lasting impact on so many issues and so many of our lives. That was true on a whole host of different issues, and it was true when it came to the NRA and gun rights. In 1977, the NRA indicated it was going to move its headquarters to Colorado to signal a retreat from politics. And at their annual meeting that year, which is still known as the Revolt at Cincinnati, 1,000 activists showed up, voted out the old leadership, voted in new leadership. that was much more intense and much more ideological, and that refocused the organization as a constitutional crusade around what it believed was the real meaning of the Second Amendment. And that was in 1977, almost 3 decades, almost to the day, before that 2008 Supreme Court decision. Nowadays, when you go to the NRA headquarters in Fairfax, Virginia, you walk into the lobby, and there on the wall, in pride of place, is the Second Amendment. It used to be in the old headquarters, it had words about training and marksmanship. Now it's the Second Amendment. But you have to look closely. It's been edited. They just edited out the part about the well-regulated militia. In fact, there's 2 periods. There's not even 3 periods. It is at the heart, edited, of the NRA's mission. And what did the NRA do, and other gun rights advocates? As I said, it's kind of a classic constitutional campaign. If you like it or not, it's how constitutional legal change happens in this country. They started with scholarship. They supported financially and backed otherwise scholarship. Some of it was very good, dealing with what the English common law rights were and things like that. Some of it, I argue in the book, was very flimsy and sort of surprisingly so, and I have a number of examples. One of my favorites is, to this day, I mean, to me, a lot of this stuff, you go and you look at the quotes from founding fathers which supposedly prove what they meant about the Second Amendment, and then you go look and see what the actual quote was. It's all available on the internet now, and it's sort of like the people who write movie posters, plucked out of context. You can go, there are law review article after law review article quotes Thomas Jefferson saying, "One must love to possess arms, though one hopes never to have to use them." This is proof of what the founders thought the Second Amendment meant. You can see it in law review articles. You can go, it's on the NRA website right now. You can buy a t-shirt with that quote. Well, gee, that's a good one. Go look it up. Jefferson was writing to George Washington. He said, "Remember that decision I made as Secretary of State? Remember I sent you those letters about that? I think I'm going to get attacked for that decision. Could you send me the letters back, please? One loves to possess arms, though one hopes never to have to use them." He was asking, metaphorically, he was asking for some letters back. But that's still waived as proof of what the founding fathers thought about the Second Amendment. There was way too much of that. But there was scholarship. There was a very concerted and effective effort to move public opinion. The idea that the Second Amendment reflects an individual right is now the common view, and you can see it in public opinion polls over time. The politicians got elected. The organs of government changed their views. The Justice Department, which had always taken the position that the Second Amendment did not reflect an individual right, changed its position under George W. Bush. And so then, when the NRA and when other gun rights advocates went to court, only then the decision, the Heller decision, sort of fell like a ripe apple from the tree. It was the way we get constitutional change in this country. And the Heller case, as I say, was very much focused on originalism and original intent. It came down in 2008, and there was, it was a big deal. It was the first one of those very controversial 5-4 decisions with this court that have led Justice Ginsburg to call it the most activist Supreme Court in recent history. But what happened after that? What did the Heller case say, and what happened after that? And that then sort of leads to the third surprise. Because what happened after that is that the Heller case and its another Supreme Court case that was its twin ultimately didn't change very much. It didn't change very much in the way we live and the way we deal with guns in this country, in the following sense. So when you strip away all the originalist finery, and I've been very critical of this case in this book, a lot of very conservative judges and scholars have been very critical of the Heller case as being sort of the loosey-goosey constitutionalism that they thought they were fighting against when liberals were doing it. The Heller case said, yes, there's an individual right, but as with any right, there can be limitations on that right. Now, it didn't say what the right was fully. It didn't say what the limitations were fully. It really was about one particular thing, which was, do you have the right to own a handgun in your home? But Justice Scalia made very clear that it was a limited right. That then fell to dozens and dozens of courts around the country to interpret that. There have been hundreds of lawsuits trying to strike down gun laws, saying that they violate the Second Amendment. And overwhelmingly, those lawsuits have failed. The courts have upheld existing gun laws. They've said, yes, it's an individual right. Some enthusiastically, some grudgingly, yes, it's an individual right, but society also has a right to protect itself. And it's a compelling government interest to have strong laws to deal with the risks and dangers of guns. And that's how it's played out all across the country. Now, we don't know for sure how it's going to be finalized. A big issue that has not really been resolved is what about carrying guns outside the home? In some places it's with open carry, as you see in Texas, where people are carrying around assault weapons. Some places it's who can have a permit or something like that, who can carry a concealed weapon. Overwhelmingly, the federal appeals courts have upheld very strict laws, making it very, very hard to carry guns around. But there's a court in California, the Ninth Circuit, Court of Appeals. There's a case there right now called Peruta, where the Ninth Circuit, which is famously liberal circuit, actually struck down California's gun law, and that may be the case that goes up to the Supreme Court. The Supreme Court has not ruled. They've actually gone way out of their way to not take another big gun case, most recently as last week. Nobody knows why. It may be that they want to see this consensus develop, and it has been a consensus that's developed in the courts. Maybe that the 4 liberals and the 4 conservatives aren't sure where Justice Kennedy is going to fall on this as on so much else. But the Supreme Court has not spoken yet, but all these other judges have. So how has it played out? As we know, on the one hand, this is the first time that we've been debating gun control and gun safety laws in a while. After Newtown, after the mass shootings at the movie theater in Colorado, the shooting of Congresswoman Giffords after Newtown, we finally as a country began again to debate what to do about guns. It's the first time, as I said, that we've had that debate with a constitutional right in the Second Amendment recognized by the Supreme Court. And politicians and others, seize the constitutional high ground in talking about this and say, I'm for the Second Amendment, I'm for the Second Amendment. It did not necessarily have that significant an impact ultimately, though, on what happened legislatively. So you'll remember that last year, one of the proposals that was brought to the floor of the United States Senate was to strengthen the background check system and extend it to gun shows and close other loopholes. And it was bipartisan, it was Manchin-Toomey. It was supported by up to 90% of the public in the polls. And it failed due to a filibuster. But it didn't fail because of the Supreme Court case. It didn't even fail, it got a majority of the Senate. It failed because of political organizing, and it failed because of the United States Senate's filibuster rules, which are also, by the way, not in the Constitution. And in fact, they were very, very worried about having majoritarian, supermajority requirements, but that's a different issue. But it didn't fail because people thought it violated the Second Amendment. People argued it was too much paperwork or it wouldn't work. This constitutional argument has not yet blocked this legislation or been so deep a factor, but I do think that it could. There's really interesting long-term trends that I worry about when it comes to guns and how the Second Amendment fundamentalism could make it harder to find common sense solutions. We have almost 300 million guns in this country. Nobody is seizing the guns even if they wanted to, but there's 300 million guns. They're not going away. The number of guns is going up. The ranks of gun ownership, however, is shrinking pretty dramatically. Fewer and fewer people have guns. There are fewer people who hunt, fewer people who are in the military. The sort of social base of gun ownership is shrinking. And gun crime, as with all crime, is going down. A lot of the things that people care about, apart from these very high-profile mass shootings, a lot of the reasons people talk about this issue are shrinking. And there are kind of solutions that are not strictly gun control laws that can make a big difference to make gun violence even less of a challenge. I was very struck in just last week, this was not in the book, but this is a recent fact I learned, that this year in the United States, as you know, we have a far, far higher rate of death by gun in this country than any other developed country. It's not close. It's not close. They're just as violent in other places, but they don't have a gun death rate. They hit each other on the head, or they use knives, but the damage of guns is much less in other similar places. But this year, for the first time, more people in the United States will be killed by guns than by cars. Now, at one level, that's, I think, a horrifying statistic about how many people, 33,000 people killed by guns. That's a lot of people. But in a way, that's not what's most interesting. It's that the number of people killed by cars has gone down so much. A lot more people used to be killed by cars. Well, why? What happened? Well, they didn't ban cars. They didn't seize the cars. They didn't stop your right to drive or to travel. They made cars safer. They lowered the speed limit. They raised the drinking age. They put in airbags. They put in seat belts and all the other technological fixes that have made cars much safer now than they used to be. There are things like that with guns that could actually make it so that children can't accidentally shoot each other, or that guns don't fall into the wrong hands, or that can trace the bullets if they're used by criminals, or this kind of background check system which uses digital technology. And I think that a lot of these things could point us toward, as with so many other things, fixes that are technological in nature and behavioral in nature that don't threaten anybody's core right if they believe they have a right to gun ownership. What I worry about, I think those decisions are best made at the ballot box. They're best made in the compromise and rough and tumble of political debate. They're really poorly suited to be decided by judges. And I worry that what I would consider Second Amendment fundamentalism, the idea that the Second Amendment means you can't have any limits of any kind on anything having to do with gun ownership, that kind of fundamentalism could get very much in the way of progress. As I said, I think that one of the ultimate lessons of this, and this is, I'm asked by people who want stronger gun laws, what should they do? And part of the answer is to look at what the NRA did. What the NRA did was totally in the mainstream of how we get constitutional change in this country. It's how we got civil rights. It's how marriage equality is sweeping across the country. It's how groups like my organization, the Brennan Center, fight for voting rights. It's understanding that it's not actually up to judges or lawyers what the Constitution means, but at every step of the way, it's up to the public. It's up to the public. It always is and always has been. I conclude, and I am very fond of a quote from a great constitutional lawyer, Abraham Lincoln, at another point in American history, another point of debate, talking about slavery and what the Constitution meant in the wake of the Dred Scott decision. At the first Lincoln-Douglas debate, he said, with public sentiment, anything is possible. Without public sentiment, nothing is possible. So consequently, those who mold public sentiment have more power than judges or legislators, because they make it possible for those judges or legislators to rule. That's what the NRA did. That's what people have done throughout American history, and people who want stronger gun laws over many years and many decades are going to have to do exactly the same thing. So that is the biography, in short, of the Second Amendment, and I'm very happy to take any questions or hear any comments that you have. So the question was, how do I consider the Second Amendment a right or a privilege? You don't want a public opinion poll or the ballot box deciding whether if you have a right, whether it's taken away or limited. We as a society, first of all, we're now grappling with the idea that it's an individual right only for the first time. It really, until now, was understood to be something that balanced public safety and the public right with the individual right. And we've always found that it was most effective to do that, as we do with a lot of rights, through the push and pull of politics. I don't mean like bumper stickers, I mean laws. Those who support gun rights have proven themselves to be very effective at protecting their rights in Congress and in the legislatures, and there's not a lot of evidence that unelected judges need to ride to the rescue to strike down laws that are products of years of work based on, what I think is a kind of a misleading reading of the history of it all. From the beginning, we evolved to understanding that what they meant at the time when they wrote it is not really relevant anymore. They were talking about the militias. We've moved much more towards a more individual concept in the country, but always with gun limitation, with laws and limitations. So, look, I think that the way you describe it, the way Justice Scalia, when you scrape away all the stuff he said about original intent, was both an individual right, but also the ability to have strong limits. It's a test. It's a question of what gets in the way of those limits. What a lot of people would argue, for example, is that something like a background check to make sure that the wrong people, somebody with a criminal conviction, say, doesn't get a gun. That is not seen, I think, by most people as violating their constitutional rights. But then there's something like assault weapons, where you might have 100-round ammunition, which is much more destructive than anything any militiaman ever had access to, let alone what we need to protect our homes or go hunting or something like that. And a lot of people argue, although the courts have upheld that something limiting ammunition or banning assault weapons is a violation of the constitutional right. So I think you can have the right, but it is a kind of right that really requires very strong public protection at the same time. Well, that's a great question. The question was, is the only vestige of the original intent that arms refers to guns? So, first of all, at the time, you're right that we assume arms means guns, but at the time they had a lot of soldiers had swords, and some of the earliest cases in the 1800s where the state courts in the first half century of the 1800s came down on behalf of what was called the Arkansas Doctrine, which was ruling that, in fact, the Second Amendment referred to militias. They were about knives, Arkansas toothpicks they were called, and Bowie knives and things like that, because the guns were, A, they didn't work, and B, they were very expensive. So they weren't as ubiquitous as we might think they were. This goes to the similar question about the assault weapons. Is there a difference in the destructiveness? In other words, a military weapon nowadays would be a bazooka or a drone or a nuclear weapon. And, do we really think people would have the right to have those in their home? In a second, sir, I'm answering this gentleman's question, and I'll get to you. One of the things that Justice Scalia did in his opinion, in my view, was like that edited and rewritten version of the Second Amendment in the lobby of the NRA building. In the 64 pages of the majority opinion, 2 of the pages deal with the militias. And the rest take the words, and he considers himself a textualist. He thinks that you really need to look at specifically what each word means. He relied on a lot of dictionaries. He looked the words out of order and out of context, and looked at old dictionaries and said, bear means carry, arms means a gun, therefore you can carry a gun. It's an interesting thing. This is where computer technology gives us some new insight into what earlier generations meant. The phrase bear arms had an almost exclusively military meaning to the people back then. Last year, the National Archives put online the papers of the 6 leading, most famous founders, Washington, Adams, Jefferson, Hamilton, Madison, and Franklin. There's 153 instances of the phrase bear arms or bearing arms used. And other than where they're saying, hey, we have a Second Amendment, here's what it says. Other than that, every single one refers to the military. So one of the questions is, these cases really have only pretty much dealt with guns, but I suppose you could, if you're really going to be a real originalist about it, you could have knives and swords and nukes and other things too. This again, my original and basic interest is I don't think that a mechanistic and robotic originalism is the right way to govern a modern country. Original intent is really important. It's one of the things you have to know about, but it's only one of the things you have to know about. What developed in the next 2 centuries and what a society needs now too also has to go into what we think about in terms of rights. Well, it was not about the Second. The question was, is there anything in the Federalist Papers about the Second Amendment? It was before they wrote the amendments. So the issue, more broadly, is there stuff about the things that impelled there to be a Second Amendment? And the answer is some, yes. It wasn't as big a factor as the worry they had that Congress would raise taxes or that there wouldn't be real representation in the Congress. They talk a lot in the Second Amendment. So the opponents, Second Amendment, the Federalists were op-eds basically written in debate with people who are invisible to us. And the people criticizing the Constitution said that it's going to lead to tyranny because there's going to be a standing army. And so Madison and Hamilton, sort of with increasing intensity, said, no, it won't, no, it won't. Madison, in Federalist number 46, talks about the militia. He says that these citizens bearing arms from home, we trust our citizens with arms, and that, don't worry, a standing army, even if there was one, wouldn't be a problem because we'll have a civil war and we'll have 500,000 militiamen will beat the 30,000 people of a standing army. So they, again, it was a different way of looking at the world, but they did talk about it, but always in the military context or fighting off tyranny. Yes, it's hard to translate, and of course there are many ways in which people who I think are the most thoughtful, a guy named Nelson Lund, who's a professor at George Mason, who is a strong supporter of the individual rights view, has written about how hard it is to translate then to now in terms of the power of weaponry now, and how does that differ from what they had then. It's a great question. The question, again, for the camera was, in talking about the book, have I had additional insights or learned? You know, I think, well, one insight was this, and obviously this is a very controversial topic, and people said, oh, wow, this is not an issue I'd written about before. My organization, the Brennan Center, is a leading group working on voting rights and campaign finance and other criminal justice, but not this. And so when I waded into this territory, people said, wow, people are very intense, and you know, you're gonna find out. That hasn't been my experience. My experience has been when there are questions I get in person, certainly, but on call-in shows or anything like that, people might have a different view or might be, without having read the book, be skeptical of some of the things I say. But they're very rooted in history. They're very focused. A lot of it is, a lot of people spend a lot of time studying this stuff. And that's both interesting and in a way very encouraging that people take these constitutional issues as seriously as they do. I was in politics for a long time. All the political consultants will tell you endlessly the public doesn't care about this con law stuff, and it isn't true. So I'll tell you after I go to Texas. As you know, this issue about carrying guns in public is a big issue in Texas right now, where a group called Open Carry Texas is trying to validate what they see as their Second Amendment rights by carrying assault weapons into fast food restaurants, supermarkets, Target stores, and that sort of thing. And it's interesting because it's really backfired. Even the NRA posted a blog post saying it was weird and counterproductive. But I wonder too if it's more than that. I think that this is an issue where on a lot of these issues there is a broad majority of the public, but the intensity, of course, tends to be more on the side of NRA members or those who see themselves as caring about gun rights. And it's a classic political science conundrum of intensity triumphing. And it's not like I think that what American democracy really needs is more single interest groups, this time on a different side. I don't think that's ultimately the answer. But maybe there's a silent majority of people who look at these pictures and thinks that there's something really backwards to try to normalize carrying around these weapons of tremendous destruction. You're right, you mentioned Georgia. The legislature there passed a law called basically the Carry Everywhere law, which makes it possible to carry guns into church, into school, just about everywhere. And government buildings, Hartsfield Airport, one of the busiest airports in the country, people keep walking in with guns, forgetting they're not supposed to. So I think that, I might or might not like that bill. I don't like it, but it was passed by a legislature and not imposed by a judge. And while I don't like the outcome, I think it's emphatically a better way to do it. So one of the themes one of the threads here about the role of guns and the Second Amendment has to do with race and especially with slavery. So one of the things during the Revolution and during that period, the militias in the South were used to protect the slave system, not to protect slaves. They were night patrols. And it was one of the reasons, if you read the debates at the Virginia Ratification Convention, where they're talking about the militias and the Army, very explicitly they're worried that, that the new government would be able to stop the militias from protecting slavery. And James Madison has to get up and say, no, no, don't worry, that's not true. It's one of the reasons the gun culture developed in the South so much more strongly than everywhere else. Much of the time, only whites were allowed to own guns, and that was the law in a lot of places. Interestingly, one of the interesting twists in all this came after the Civil War, when in the wake of the Civil War, hundreds of thousands of freedmen went back south, having served in the U.S. Army, and were promptly terrorized by the Klan and other white militias and vigilantes. One of the purposes of the 14th Amendment was to make it so that those former slaves could get guns. Now, it's a debate about whether or not they were mostly focused on blacks and whites being treated equally, or whether they meant black militias could compete with white militias, or whether even though some of the radical Republicans, as they were called, who wrote the 14th Amendment, that isn't how they sold it to the public in the 1866 elections, but still, that was very much in people's minds. But even then, the military governments of the South enforced the 14th Amendment, made sure blacks and whites were treated equally, but had very strong gun control laws and banned what one of the generals called the barbarous practice of carrying weapons. So, you know, again, it's an interesting and mixed picture. You know, some of the worldview that we see expressed nowadays about this from the NRA, it's very hard for those of us who live in cities to fully understand the worldview of people who live in the rural area and vice versa on this. When I was working for Bill Clinton as his chief speechwriter, he fought for and passed the Brady Bill and the assault weapons ban. He, of course, was from Arkansas. He was very proud. You know, half the people in Arkansas have a hunting license, and he thought he could really speak to the hunters in the NRA. And he used to say, you know, we passed the Brady Bill, not a single hunter has had their gun taken away. I'm not so sure that that cultural divide is what's at play anymore. If you listen to Wayne LaPierre, the leader of the NRA, if you listen to the rhetoric at their convention, it's much more insurrectionist. It's much more about fear of government. When you hear after Hurricane Sandy, Wayne LaPierre said that there was mass looting and with a real racial tinge in what he was talking about in South Brooklyn, when in fact it was the safest time ever on record in Brooklyn. There's a different worldview, and I have no doubt that racial fears play some role in that. So the question again for the camera was, I referred to the insurrection. I referred to the idea that the Second Amendment was to protect against political tyranny more than anything else, and that's what's expressed by some of the people now who, like the rancher in Nevada, Clive Bundy, who refused to pay his grazing fees and said he was fulfilling the founding fathers' wishes and waving his gun around. It's an interesting question because you'll hear people say that. In reality, it's pretty clear to me that the framers did not mean everybody was their own militia. In fact, the right to rebel was not an individual right to shoot any government agent you didn't like. It was really much more political. It was, if you look for starters at Lexington and Concord, General Galvin, who was the commanding general of NATO, wrote a book about the battles. And even these battles, which you go see the statues of the solitary lone fighting farmer standing there with their musket, they were actually really complex military units that were part of the local governments of these towns and the colony. And Shays' Rebellion, which, as I mentioned, was prompted George Washington to go to the Constitutional Convention, was a rebellion against the authority of government. They were very worried about those kinds of rebellions. And then, at the time they were ratifying the Second Amendment, they had the Whiskey Rebellion, which was same thing. People said, we're the militia, we've got our guns, we're gonna not pay the taxes that Alexander Hamilton wants us to pay. And George Washington himself rode out and crushed the Whiskey Rebellion. So I don't buy the idea that even if the view of the founders is how we should govern ourselves, I don't think they meant what Clive and Bundy meant. But it is the case that the rhetoric is much more anti-government, much more insurrectionist. That is a recent turn in American history. It's gone back a few decades now. I don't know if you all remember, but President George H.W. Bush, resigned in protest from the NRA over its rhetoric around the time of the Oklahoma City bombing. Because again, it was incendiary. I have no doubt that Barack Obama being president has stoked that, but it didn't start it. And that goes to the question of, I don't know that there's a silent majority of hunters in the NRA, who could be persuaded to not mind, common sense gun laws. And I think part of the answer is, I'm not a strategist for a gun group or gun rights group or gun control group, but is to tell the true story so that people understand, whatever they may think, it isn't unlimited gun rights, or certainly the right to use those guns to rebel against the legitimate government, is not the story throughout the country's history. It wasn't what they meant then, and it isn't how it played out in the next 200 years. Well, I think there needs to be a long-standing public argument on this. What I learned from doing this book tour is there are a lot of people who really do care about the history, and even you see this with the Tea Party. It's not an accident that people feel passionately about the founding ideals and what they meant. So it's important, at the very least, to point out what they didn't mean as well as what they did mean, at least in my view. Anyway, thank you all very much. I really appreciate it.